Okay. All right, we have everyone that's starting to join us and log in right now. Guys, I am so excited about this webinar today. I always get happy when we do our paralegal webinars because they are so special. And we've got these amazing speakers with us today that we're bringing back. You're going to love Susan and Georgia. And of course, Cash, she's going to be moderating for us. Doug was not able to make it today, but he might pop in a little later. We will see if he's able to join us. But if not, you guys will see him again very soon. If you have any questions, I encourage you to ask away. Put those questions in the Q&A box so that way we can monitor them. And then also just know that if you need anything, you can email me at ginger@connectionology.com. We are always looking for speakers, and there will be even more webinars that we will be adding to our website in the coming days. Thank you guys so much who made it to Texas with us about a week ago. We had an amazing seminar out there, and we have more seminars, live ones that are coming up next year. Right now we have our national seminar, which is incredible. That's going to be May 4th through the 7th at the West End. Those details are on our website right now, so get ready. The agenda will be coming out very soon, and we are really excited about that. All right, I think we're going to go ahead and get started. You guys all already know who my name is. I'm Ginger. I'm the Executive Director of Connectionology. Love working with all of you, and thank you again for all of your support. One second while I get our little mascot real quick. Every now and then he likes to make an appearance. But let's get started with our amazing moderator. As you guys know, Cash, he is a well-respected attorney out of Seattle, and he's dedicated to representing his clients. He began his career in a small personal injury firm in 1986, but he later left private practice to gain trial experience at a Whatcom County deputy, or as a Whatcom County deputy prosecutor. And after that, he had a brief tenure as an insurance defense firm, and he opened his firm, which is Cashton Sessler PS, in 1991. And for the past 20 years or more, he's actually been dedicated to representing individuals in criminal defense as well as personal injury cases. So one of his defining advantages is that he has worked as a prosecutor and as a criminal defense attorney, and also as an insurance defense lawyer and a personal injury lawyer. His experience working on both sides of these issues has helped him better understand the strength and the weaknesses of all of his clients in their cases. And as a criminal defense attorney, Cash knows from experience that prosecutors represent attorneys or respect attorneys who prepare each case as if they are going to trial. So that is how he approaches every case. And he personally and successfully represents hundreds of individuals charged with a variety of crimes across Washington over the last 2+ decades. As a personal injury lawyer, he knows and he uses attention to detail, which often means that he knows the difference between a fair settlement and an unjust one. And he thoroughly investigates each case and takes time to prepare each client through every step of the process. Cash is a dear friend of ours. Again, he speaks on many webinars that we do, as well as moderates, and we see him a lot of events across the country. We are honored to have Cash with us today. We're going to have a lot of fun, so I hope everyone enjoys this webinar. Thank you, Cash. I'm going to go ahead and hand it over to you.
Thank you, Ginger. And it sounded like Coco made her appearance. Thank you for putting together and organizing another great seminar. I don't know how you do it because you're putting together several seminars a week. I don't know of anyone else who has such a heavy load schedule, and yet they always seem to just progress smoothly. Everything's organized. You're on top of it all. So thank you. And just let me say, welcome everyone from the West Coast to the East Coast and everyone in between who's attending today. We're lucky to have two top-notch paralegals speaking for us. We have Susan Staggs from the O'Mara Law Group, and we have Georgia Kent from the Douglas Beam Law Firm. Those are both Florida firms. And they're going to speak to us today on how to prepare for mediation and also getting ready for a deposition. So I'm very excited to learn today what they have to offer. I'm right now without a paralegal, and I'm looking forward to picking up some tips and tricks. So when I do hire someone, I have an opportunity to pass on that knowledge. Before I go into their bios, I want to thank our sponsors today, just really quick, HMR, Fox-AE, and OnPoint Nurse Legal Consultants, and we'll talk more about them later. But let's start talking about Georgia. She is the Senior Litigation Paralegal for Doug Beam's law firm in Melbourne, Florida. The firm handles personal injury cases, including traumatic brain injuries, wrongful death cases, trucking injuries, premise liability, civil rights cases, negligent security cases, and then just to make sure that they're not slacking off, they do some criminal defense work and the occasional construction lien case. So Georgia is very experienced across a wide variety of subjects. She has 25 years of experience. She found her passion doing legal work after studying computer engineering, after getting her BA or her associate's degree in business administration. And then she decided paralegal is what I want to do. She attended Florida Atlantic University's paralegal program. She brings all of this experience from all of these educational backgrounds and her creativity to work every day and helps to keep the firm organized and moving forward. Then we have Susan. Susan Staggs, she's our other speaker today. She works at the O'Mara Law Firm, or I'm sorry, the O'Mara Law Group. Her firm handles criminal defense work, family law cases, and mass torts. She studied at Valencia and Seminole State Colleges. She is nationally certified paralegal since 2008. And I have to say that my state doesn't have any certification, state certification. So I was surprised to learn that there actually is a national certification. Of course, she's also a registered paralegal with the state of Florida. Presently, she is the Mass Torts Coordinator for the O'Mara Law Group. She's a member of the faculty for the Mass Torts NTMP program, Paralegal College, and is also getting the National Trial Lawyers whipped into shape. She's presently getting their program up and running, and she's a speaker there as well. So thank you, ladies. Please take it away and share as much as you can with us because we're anxious to hear. Thank you.
Thank you. You've given me a lot to have to live up to in this one.
I'm sure you both can do it.
And I'll tell you, I've actually been doing this for 36 years now, and I would not change anything. I love what I do. I think that paralegals that love what they do can bring a different dynamic to a law firm, whether it's a small one or a large one. And I think you have to have a certain amount of love for what you do or passion for what you do in order to be able to do all the little details that we're going to be talking about today.
And sometimes to put up with those clients that make life really difficult, right?
Yes, yes.
But I mean, I was thinking about it today. Just also, one of the skills that you both bring to the table is handling people, right? You've got clients who they're lovely people. Oh, yes, I'll get you those medical records. I'll get you those family pictures. I'll do this, I'll do that. And they never come through. You've got the clients who are like, what? I have an attorney. Why do I have to do anything? Isn't that your job, right?
Yeah, yes.
So, yes.
Sometimes we handle that better than others.
And then you're also dealing with just people on the other end when you're trying to get medical records or something. We're overworked, we're not paid enough, and we're not going to help you. So,
well, of course, I get the pleasure of doing the family law cases, which are just, a lot of fun, but actually very rewarding. So I have to say, but definitely in that civil and family and criminal are a little different, obviously. So I was going to let Georgia go ahead and start because she's very passionate about what she does and about making sure that 101, those that what this topic is about, that those fundamentals are met. So, and she does primarily civil. So I'm going to just kind of pop in as she goes along, and then we'll kind of keep moving with it.
Oh, well, thank you, Susan. I appreciate that very much. I know that both of us have a lot of experience in this, but you know, everything, I think the first most important thing when you're preparing your attorney for either a deposition or a mediation is you really have to start thinking about what kind of case you have, whether that's a family law case with Susan, or whether it's a civil litigation case. But you have to look, civil litigation is such a wide realm of cases. You have to kind of start with your case type and start just kind of know your case, know what you have. And when you do that, you have to start trying to paint the picture. I think a lot of times coming into this, a younger paralegal might be a little apprehensive and say, oh, I have no idea what my attorney's going to want. So you have to sit and you have to think about your file, and you have to start with just the basics of the file. What is going to paint the picture of what happened in your case? For example, if it's an automobile accident, you have an accident report. You may have a demand letter, which would be a great summary for your attorney, quick reference. So you look at those basic things to start off with. You start pulling together that information, answers to interrogatories that your client has given you, so that information is together and right handy for your attorney. I know Susan and I had talked about earlier that, you know, there's differences in the way you organize the material. We were talking about electronic versus notebook. Well, I happen to work for an attorney who he's not a fan of notebooks. I've been with people that were. So for me, I prepare a notebook, which ends up looking more like a Redwell with folders. Same difference. You've pulled together your documents. I don't know how specific we're going to get. I know this time goes really quickly, but there are some base documents. So I'll give you a few. Your accident report, records of property damage if it's in a medical malpractice lawsuit or an incident, motor vehicle lawsuit. You have your complaint, your answer, any requests for admissions. Mainly your interrogatory answers, because that is what has been verified by your client as the information that the other side has. So you want to make sure that your attorney has that on hand. You want to make sure that if there's any changes to that since the date of those responses, that's noted for your attorney. I guess in my mind, I try to do a quick reference sheet. You can call it a matrix, you can call it an outline, but you put all the pertinent information, dates that you're going to need, any oddities that are involved with the case. You want to make sure that quick reference sheet is going to have all of that information for your attorney. And that's part of the gathering of information. I consider myself an information gatherer, and sometimes I have to go to the client that we had this information, what has changed, talk to them before all of this transpires. And I guess I'm talking more about mediations right now than I would be a deposition, because I think some of the base information that your attorney is going to want to have in his mind, or for him to refresh himself on the case before he goes into either of those scenarios, those base documents are going to be critical. Then you're going to add to those. And that's for civil litigation. You're going to have your most recent medical treatment. If you have a doctor who is really great at pulling things together and gives a good summary in his medical record, you may take that and highlight that for your attorney, and that becomes one of the documents for your notebook. You might want to well, you'll definitely want to have your medical bills handy, a summary, a sheet of what your damages are in the case. And I guess I'm talking more on a on a motor vehicle accident than others, but you will have damages in any case. So you're going to be looking at what expenses has your client incurred. You're going to pull that together, whatever that may be. If it was a premises liability, how are they doing now? Is their injury a permanent injury? Are they still suffering with things today? Those are questions that your attorney is going to want you to be able to have in a quick reference for him, so that when he moves forward, when he's studying, for the deposition or prepping for his mediation, whether that be, sometimes it might be the day before, he may have the luxury of a few days before, he may be getting it that morning for something that's going to take place that afternoon. So you want to make sure that you have together all of those highlights for your case. So that's where the paralegal's knowledge of the working of their case is going to come in handy. What have you done? What do you know about your case that you want to highlight for your attorney? And don't be afraid to write it on a Post-it and put it before him, or ask him a quick question. If there's something that you think is missing, write it on a Post-it, put it on the top of whatever folder, notebook, whatever you're preparing for him. And don't be afraid to ask your attorney. If you're uncertain or you think you've got it all, go to him and say, I've got you this, and this. What else do you think you'll need? And for me, I'm very fortunate. I have an attorney who will talk to me, who values me, who will ask me, if there's something else he needs, or sometimes he'll just take it and run. When you get in sync with an attorney, you can usually kind of think about what they're going to need.
And for
Susan,
me,
please.
no, you're good. If we're going to reference mediation, which is where I'm at right now too, and of course, like I mentioned before, I mostly do family law, so you excuse me when I do my references, but I'm really going to speak kind of in general of how I do it for mediation. And I'm in Georgia. I know exactly what she's doing. We have one attorney in our office that does the same thing with folders. The attorney that I primarily work for, which is Mark O'Mara, he does like an actual physical notebook, but we always, especially since COVID, we do a virtual notebook. So we do both. So my steps, I kind of try to do this in exact steps. So first, I always come up with a theme for my case. Most every family law case has a theme that people, if anybody on here does family know, is called PEACE. And it's parenting, alimony, equidistribution, child support, and everything else. So the PEACE anagram. But I also, with my civil cases and mass torts cases or anything else we're working on, try to just come up with that theme. What's the theme for my case? Which is like she was saying, you got to come up with what's your premise. And I start with that. And then my outline is it's pretty simple. It's pretty standard every time. When I do my notebooks, I have an index, right? The index is going to have what's going to be in that notebook. When I have my theme, that's going to be my general information, especially in family law. But even in civil, I put whatever, for example, the civil date, I would have the party's information, as much as even their date of birth, the date of the accident, any relevant dates that need that information, and anybody that's involved in this dispute. Then the next step for me is to communicate with my attorney. What does he want? What is his goals for mediation? I make sure that we have a draft of a mediation agreement. What do we want out of this? That my draft is going to be ready for that notebook virtually and inside the notebook. Virtually is better because it's going to be in a Word document. If I need to, I'll prepare a mediation brief, basically just for my attorney. Sometimes we'll send it to the mediator as well, that this is what we want, our client wants. This is what our client wants out of this. Then obviously you organize all the documents that you need for mediation. That could be anywhere from the documents that Georgia was recommending, your accident reports, any of your discovery that's going to be relevant. Obviously in family law, we have financial affidavits, things that related to their income. But organizing that well, that it's very clear and concise to your attorney, and he knows exactly where to find it, especially when you're doing virtual. That's important. We can get into that in just a little bit and I would love to hear from everybody on how they organize virtual, because keeping that in a certain way, in a certain level, because you don't have control, right? You don't have a notebook where you can put these things in order that you want them. That computer takes over. So you've got to make sure you've got it labeled. So that's going to be succinct order for your attorney. Obviously for mediation, I want my client's notes in there. Anything that they've discussed that they want to get out of this, and that they want to know. I always ask them, what's your questions? What do you want to have for this? What do you want to make sure that is expressed in this mediation? Emails back and forth on negotiations. I want to make sure those are in there, that we know what's been going on from day one. And then of course, as we mentioned, any supporting documents that go along with it. Now, again, we can get into this further, but if your mediation, you got to know if it's in person or virtual. If it's virtual, where's everybody going to be at? Like right now, I'm doing one of my biggest pet peeves. I've got my window open back here, my shade. So I've got a glare. I want to make sure that my client for mediation and deposition is somewhere they're not going to be interrupted, somebody where there's nobody else in that room, that there's not a taint in this deposition or the mediation. And I'll stick specifically mediations, but yeah, that there's nobody else in that room, especially for family law. And then obviously the last step is to coordinate any meeting with our client, but that at that point, my notebooks are ready, virtual and the actual notebook itself. And it's sent to whoever it needs to be sent to, whether it's the mediator or sometimes we'll have expert witnesses that will attend mediation, so they have it as well.
Yeah, may I ask a question? What is the practice, or do you folks ever send your mediation brief in advance to the opposing counsel, the decision makers, if it's an injury case, to the insurance company, saying we want the decision makers to review this mediation brief? And if so, even if the mediation brief isn't due until a week before the mediation, do you send that out 60 days in advance, 30 days in advance? Is there any kind of internal deadlines not put on that you obey or follow, not that the mediator puts on you?
For us, sorry, Susan, I'm just going to
Go.
jump in. For us, we do not typically do any kind of mediation summary to the opposing party or to the adjusters. We may provide updated medical bills and records if there's something new that we want them to evaluate, so that they can value the case higher. But typically what we would do is, prior to, we might send a mediation statement to the mediator only, confidential statement to the mediator. At least that way the mediator has the information that we're wanting to make sure can be relayed in whatever confidential manner that the mediator can do. So he's got that for his use. But as far as giving the opposing party, that's not something that we would typically do.
I'm starting to do mini mediation briefs to the decision makers on the other side, not necessarily everything I share with the mediator. So I just wondered, if anybody's doing something like that.
Well, I think sometimes by the time you get to mediation, what we've done a demand letter. We've probably done a civil remedy notice and outlined very detailed, here's where we are, this is what's happened, this is what you've done, and this is why we're going to mediation, because you haven't paid us yet. I know that's a little bit shortened on a summary.
No.
But and I, again, I work for Douglas Beam, so he has a way of being able to relay us the story of the case. He's very compact. This is it. This is the way it is. Pay us, and then we break out and start whatever's necessary. So I think I have seen mediation summaries done before, but typically when we've done those, they've only went to our mediator, unless it might be a larger, maybe a construction wrongful death situation where we have high-level management in the opposing side, that we might want to put together a synopsis of here's everything, and this is where we are, and this is what your expert said at whatever inspection, that kind of thing.
in prepping your attorney for the mediation. You talked about doing a mediation summary for the attorney, or just kind of the summary of the case. Is that limited to 1 page, or do you find that to be impossible? Is there a page limit on that?
Mine are an average of 1 page. Like, because I'm just giving a brief synopsis, just a brief description of what, just general information, like I said, and then under each category that we have a claim for, basically what we want out of that, what our goals are for that. Because now you got to remember, and that's going to be, I kind of use that as a tab too, right? When I'm doing my indexing, they're going to find what I've described in that thing. They're going in that paragraph or 2 paragraphs, they're going to find that in a tab in my notebook under that section of all the documents that are relevant to it, any negotiations that are relevant to it, and any exhibits for the sake of mediation. We don't have exhibits, but I will put exhibits in there that I know we'll be using so that they're relevant, so that they're accessible to him if he needs them.
Yeah, it's like the old crib notes or a cheat sheet, if you will. So I do the same. I keep mine, as brief as possible with basically the highlights, prior history, what's happening now, what kind of offers and proposals for settlement maybe have been out there, what's the coverages, how much is in play with coverages. What's the total medical bill picture, any additional expenses, and then, the highlights. And then, as Susan was mentioning, everything else will have its own either tab within the notebook or in its own folder. So if the attorney needs more detailed information, he can pull that out and it's all quick reference for him. And tabs, tabs are great tools. Tabs and Post-its. I mean, I live for those. I'm like an office supply crazy person. I mean, tabs, Post-its, if I can stick a tab on a note to my attorney, then I know he's going to see that one. And in my brain, it might be something important. He might just look at it and say, but at least I've done my part. My part is to gather the information and highlight what I think that he's going to want to know.
No, I love it when I get tabs, as you put it, or just even, okay, here's my client's deposition testimony, but here's a page where we just have what you might think are the important things of that testimony, right? Here's where the client talks about my current complaints. Just lift it out of the deposition and attach to it, so I can just find it right away. Or as you say, a tab. But yes, that's really helpful, especially when you find that you don't have as much time as you thought to prepare for the mediation. So yes. So I'm sorry to interrupt you.
Oh, sorry.
I really want to encourage our participants today to send in questions to the chat and the Q&A. So let's ask just a couple of those, and then I'll let you guys get back to where you're at. Somebody's asking if you could provide a copy of a sample notebook, the table of contents, or the index. And then also, is the virtual notebook simply a PDF copy of the paper notebook in Adobe?
Good, all great questions. And yes, I can provide an index of the notebook, and I can even provide I go by general outlines. I keep them and then I fit them with my case. So I'd be happy to provide those in Word document as well. But no, the virtual court file is definitely not just a PDF format of that one, of the actual notebook. It can be. A lot of your documents in those folders are going to be PDFs, but some of them will also be your Word documents, your digital files of something. Obviously, make sure anything that you're giving over to somebody else is protected and formatted correctly. But to say it's just a PDF version, it's not where I took the notebook and I scanned everything in. It's where I make folders for everything. So you'll have a digital folder just like you would on the index. And that's going to be general information, pleadings, exhibits, notes, case law, anything that would be, and I could probably, if I can get it, when we maybe take a break, I can try to bring one up where I show you kind of what that looks like for me. But it, again, it's that art and that science of putting it together so that in a folder, right, you have everything where you want it to be. When it's digital, you've got to make sure you label it either with ones, A's, alphabetically, however it's going to fit, so that it's in that order that you want it to be in. But you will just make the folders just like you would for the sections of your notebook. Apply everything in there, but you just got to and apply. So just say, moving on to, if I just reference, which we'll get to, which is depositions, making sure those exhibits are, you have digital, like I have a digital folder of exhibit stickers that I put right on my document. So just like little variations like that, but it's, once you get into it, it's fun, and it's it's exciting to do. That's why I would love to get tips on how everybody else does it, because it's just sort of like an art form.
Totally agree. And one of the things that I've noticed for my electronic notebooks, a lot of times that is going to be the paralegal or even an associate lawyer who's going to be attending with the primary lawyer for whatever event that it may be. Because as things go along and you're listening to what is happening, you may have a need to quickly get something for your attorney. For example, at a mediation, if the defense counsel has brought to light some kind of medical record that they've seen somewhere, or taken some kind of note from a doctor and pulled it completely out of context, you want to have your records together, OCR'd, which is optical character recognition, so you can do a quick search, put your hand on whatever can contradict what they have just said, and get that to your attorney, either to combat them at mediation, give to the mediator, or to help calm the client who is going to go into that breakout room and be completely upset with what has just been said by the other side. Same thing for a deposition. If the deposition is ongoing and something comes to light, and you know about maybe testimony from a deposition that was taken 2 years ago, you do a quick OCR or go down your index for that depo, you pull out that prior testimony, and you're able to slip that to your attorney very quickly. So the electronic file, for me, I'm thinking that it needs to be like next level. You've got your notebook, which is your basis that's going to flip through. Your electronic folder is going to have a lot more detailed documents, exhibits, accessible, and in a format for you to find information as quickly as possible. Because time is what's critical, because your attorney's not going to stop and say, oh, wait a minute, I need to talk to my paralegal for a second. They've got to get what you're seeing for them and be able to just keep everything in pace.
So true. And I actually enjoy my digital notebooks a little bit more, and my attorney knows this as well, because when we're somewhere in a deposition, mediation, or even in trial, I have my own Surface, Microsoft, not putting a plug for them, but I have a Surface, he has one. And, I can put stuff in my Surface, especially and again, it goes what format you use, right? For your virtual. Some people, you can use Google Drive, some people use Dropbox. We have an on-cloud system for our case management called Smokeball. Mine are right in there. So it's so easy for me then to put as much in that notebook that I want, that I think I might need for backup. Doesn't matter if he knows it's there, he doesn't need to touch it. He has his basics where I've, tabbed them, but there's also extra stuff in for me. Or say I'm not at a hearing, I'm not at trial, I'm on maybe Zoom or not even there, and he emails me and says, hey, I need this in the trial notebook or the virtual notebook. On my system, it takes me 2 seconds to hit move over, and it's right in his notebook instantly. I mean, I actually love virtual notebooks way more than but there's, there's a lot to be said for that handheld too, right? When you're in trial, you have to have that handheld, unless you've got 5 iPads where you can hand the judge, hand the witness, and hand whoever can look at the exhibit. You got to have that handheld. But the virtual, once you get used to doing the virtual notebooks for mediation and deposition, hearings, everything, it's priceless.
Yes.
And I'm sorry,
And if
what
you
was the
have
name of the
an
program?
old school, oh, I'm
My
sorry.
program's named Smokeball. It's a case management program. Definitely not trying to plug them, but cannot say enough about them. It's also it's not only a case management software that's amazing. They also it tracks your time. It tracks almost everything and anything but a phone call. It doesn't track a phone call, but if you're drafting a memorandum and it links to your calendar, it will track your time that you're on that phone, you're drafting that memorandum, that whatever that call time is set for. When you're in a document, within seconds, it will stop once you stop working on it, but it tracks your time.
Nice.
I'm sorry, I didn't mean to interrupt you, Georgia.
Sorry.
No, that was okay.
Me neither.
I don't remember what I was going to say. I think it had something to do with the virtual and how, oh, I know what it was. I was going to speak to the old school attorneys, because there are a lot of attorneys that they are not fans of the electronic, the new electronic platform that we have all seemed to be gearing towards in this day and age. So they really become reliant on the paralegals to assist with those kind of things, so that we can just keep things moving, but yet be able to print them that paper that they want to hold in their hand.
I think we have Lisa from OnPoint Nurse Consulting, Legal Nurse Consulting, with us, and I know she wants to talk to us a little bit. Lisa also has a really impressive resume. She was a nurse, a staff nurse from 1983 to 2022. And she's not just a consultant, she's someone who actually has experience in the field, clinical work. And I can't tell you how much of a difference that makes to me as an attorney, Lisa. So your background includes cardiac and critical care nursing, I understand. And you right now are in charge for OnPoint Legal Nurse Consulting. You're the program director for the consulting division. So tell us exactly what it is that you do for attorneys like me, please.
Thank you, Cash. Thanks, everybody. It's good to be here again. It's been a little while since I've been a speaker at Connectionology. But like Cash said, I am the program director for the consult service at OnPoint Legal Nurse Consulting. OnPoint has been around for about 20 years, could be a little bit longer than that. It was initially founded by Mindy Cohen, who has since sold the company, but we are a full service litigation company and very happy to support our attorney clients and our paralegals, as the case may be. So we have 4 different programs at OnPoint which can help you. I am the program director for the consult service. And so if you had a case that you needed to screen for merit, or you've already started litigation on a case, but you need a top-notch chronology or case analysis, we can handle that for you. And we also do hyperlinking now, which makes it easy to click on a chronology and bring you right to the medical record. So that's been super helpful for our clients. And I try really hard to match the case with the consultant. So if you have a birth injury case, I'm gonna get you a labor and delivery nurse or a NICU nurse to review that case, and that helps in a couple of different ways. Number one, they have the most knowledge about potential injuries, but they also are so familiar with the type of specialty records that you see in a labor and delivery setting that they're going to be able to go right to what they need to save you time and money when they're going through the medical records. And then they'll also be very good at being able to identify any missing records for you. And under my program, we also do pain and suffering reports. And that's one of the things I enjoy doing the most. It's a great way to highlight your client's non-economic damages. So it's been a really, it's been a really gratifying experience to work on these pain and suffering reports. And OnPoint handles it in a couple different ways. If you are expecting to have the author of the report testify for you, then it's considered an expert report. but we can also provide a very similar report as a behind the scenes work product, which is a little bit more cost effective because you're not paying an expert rate for the nurse who's authoring that report. And then some of our other programs, Ingrid Sideroff, who you've seen on these Connectionology webinars, is a master's prepared gerontology nurse. She heads up our long-term care and nursing home division, and she's just excellent. She's got a team of nurses that are great at putting together merit screens, chronologies, and reports for anything that's related to long-term care, nursing homes, assisted living, what have you. Dawn Montano is our director of expert witness location. She also has a team of nurses to locate experts for you across the country. They keep a very well-rounded and up-to-date database and are able to get experts for you in a very timely manner. Dawn's program also encompasses life care planning and future medical cost projections. So if you have somebody with a catastrophic injury that you need a life care plan for, or maybe a little bit less of a catastrophic injury, but we still need future medical cost projections, Dawn is the person to reach out to for that. And then Rachel Prock is our director of record retrieval and record organization. She'll work with you to obtain all the medical records that you need for your case. And then we have a team of in-house nurses who are organizing the medical records for you. So if you need it OCR'd or bookmarked, if you have something that you need bookmarked in a particular way, Rachel's team is able to handle that for you. We're actually working with one attorney right now who has very specific needs for his bookmarking, and we've been able to get him some medical records back that suit him, but also make it much easier for his experts to go through the medical records. So again, saves you some time and money when your experts are looking at the medical records. So I will leave my contact information in the chat box, but we hope to hear from you. And I'm enjoying this presentation. So thank you for that opportunity as well.
So before you go, we've got a couple questions.
Sure.
One of our listeners wants to know, what general items do you include in a pain and suffering report or summary?
So typically, especially if it's an expert report, it's a narrative summary, and we include my methodology is to just go through all the medical records and talk not only about somebody's physical pain, but that like you can have an injury that requires CPR and then you're intubated and on a ventilator. So the injury is one thing, but medical interventions that are involved post-injury can be intense. So it's in a pain and suffering report, it's one thing to say the patient had a cardiac arrest, had to get CPR, and was put on a ventilator, but it's entirely different when you're going through the medical record and you see that because the patient is agitated and trying to extubate themselves, their hands are restrained. So they're laying in bed with both hands restrained. Or I did one pain and suffering report where a chaplain's note talked about how the patient had tears running down his cheeks. So we're looking for all of those little nuggets that really tell the patient's story, because most of the time with a pain and suffering report, the patient's not able to speak for themselves.
Well, and I'm embarrassed, but once I had a case where my client's leg was fractured, and I thought it was just a typical leg fracture until it was pointed out to me, no, with this particular kind of fracture, it's incredibly painful, it's excruciating, and usually the EMTs on the scene will literally hold on your client's foot, and then somebody grabs them by the shoulders and they try to wrench the leg back into place. And just having someone explain that to me, I mean, that increased the value of that case tremendously.
Sure.
And just reading the medical records, not having a medical education or background, it would have just gone right over my head. So it really is critical to have somebody, a nurse, read the records and educate the attorney as well. So,
Yeah, thank you. We take great pride in our ability to go through those records and tell the patient's story.
yeah. So medical, doctors, they always have this habit of using this kind of very bland language that minimizes everything and everything's always getting better. And so that's where your pain and suffering reports are just fantastic. So,
Thank you. Thanks.
and also I think the other, of course, you're helping to find experts, but sometimes experts come back to attorneys and say, summarize for me all the times that this patient had symptoms of a lower back injury. That's something that you can take off our hands and do much better than the attorney. So,
Exactly. Correct.
and I see Blue Edwards here. He's here with HMR. He's your man at HMR. Just the other day, I had a young attorney and he was just fretting and worried about where he was going to come up with the money to fund his client's case, to get the money for the experts. And he was saying, I can't keep laying money out for my client. I'm getting too heavily vested. As an attorney in Washington State, that's a big deal. We're not allowed to put out too much money of our own because it compromises us ethically. Then, we might want to settle that case rather than hold out and do what the client wants to do. So to avoid that compromise, it's HMR to the rescue, right?
Awesome. Thanks, Cash. And hey, it was great hanging out with you in Fort Worth. I had a great time. It was good to getting to know you, man. Susan, Georgia, great talk today. Obtaining and gathering case info is probably one of the biggest challenges that we all face, right? So a lot of really good nuggets of information here today. Appreciate it. So who is HMR? HMR Servicing. We are the premier funding source for personal injury plaintiff law firms nationwide. We specialize in catastrophic injury cases, basically traumatic brain injury, spinal cord damages, amputees, the full gamut, right? There's 3 offerings of funding that I'd like to just go over quickly with everyone today. The first of which is going to be case cost funding. So what is that? Get the experts you need to prove up your case. Like Susan was mentioning earlier, life care planners, OnPoint Legal Nursing, Fox-AE, they create great videos. These are all things that obviously build up and shore up your case so you can go and do the best, right? Yeah, get the best settlement, take care of your client financially, all the things. So that's the first thing. The second thing is going to be medical funding. For medical funding, we currently operate in 39 states, meaning that we work with providers and medical facilities nationwide. Also, I always like to say, if you guys have doctors or medical providers that you love to work with, we would like to work with them too. Don't let that keep you from reaching out to me if you're in need of funds for that. Big surgeries. We fund a lot of spinal cord surgeries, TBI treatment, things like that. And all of our providers are top notch. Yeah, if you guys have any questions about that, please reach out to me directly. Last but not least is pre-settlement funding. This is a hard time for your clients, right? Possibly the hardest time that they have had or will have in their life. So a lot of times they need money to live and survive and pay their mortgage and child support and all the things, right? I've heard it all. So that's an offering that we offer as well. Obviously, it's a case-by-case basis. But again, feel free to reach out to me anytime. I'm going to post my my contact in the notes section here. And Connectionology, what a great organization. We love being paired up with you. And thanks again.
Thank you, Blue. So, who wants to jump in now, Georgia or Susan?
Well, hey, I just want to apologize. I just lost a monitor. So I was like,
Okay.
this now perfect example, right? Segue into getting virtual notebooks set up and what you have to do. If Georgia, I don't know if you're ready to move on to depositions.
Sure.
When we kind of
I'm-
tied
I'm
into them a
game.
little bit, but George and I were talking, my deposition or my mediation prep is probably not as intense for family law as it is for civil cases, but civil deposition and family depositions, I think, are probably just as similar and intense in how we do that. And again, I can't stress on how much I always need a theme. I try to start off every case of what my theme's going to be. And I even try to give it a funny title if I can, but what are my goals and what are the outcomes and what do we need to get from this deposition, right? So I'm going to go with my instance is going to be, say, for my client, right? It's going to be my client's deposition. And again, I have specific outlines, generic outlines of what to follow. What do I want? I actually have two, and I really should combine them someday, but they start off same thing as mediation, right? Case gathering, getting that information, all the relevant documents, pleadings, discovery responses, anything, statements that's going to matter for that deposition. Obviously, this is standard. You meet with your attorney, coordinate what are the goals, what do we want out of this witness. If it's a witness, if we're taking the depo, what is going to expect of our client? Obviously, you don't know what they're going to ask, but for your client, getting them ready is key. I also want to identify any key witnesses that we either have taken a deposition of or they're going to take a deposition of. So I know, especially if we've already taken their deposition, what they've said and how that's going to be relevant to my client and what they testify to. I will always try to contact most of my witnesses, no matter what, if it's a witness deposition or my client deposition. I want to have almost all of my witnesses already spoken to before any depositions are taken so that I have their statements in my notebook for whatever reason, because so many times you're in a deposition on it. I'm sure you guys have been there where your client says something and you're like, wait a minute, is he sure? Or your witness says something and you're like, I know somebody else testified differently, so that you can be ready to tell your attorney that with a note or whatever you need to. Obviously the deposition materials that you're going to put in your notebooks, exhibits. And like I said, I kind of have a separate outline for all of that for my notebook. So, getting what I want for my notebooks, which is going to include exhibits, transcripts, correspondence, depo questions. Those are all going to be in my notebook. But again, identify that later after I've said, this is what I'm going to put in my notebook. Preparing, possible questions that your client might, you can expect your client might get. We go over what's going to be privileged information. I mean, you know pretty much what a client's going to be asked, what the issues are, so that you make sure your client understands what would be considered privileged information that he's not going to, that he doesn't need, that he needs to stay away from, doesn't need, and how to prepare him for that. Again, logistics. Right now, since I had to move my camera, I can see I'm extremely dark. Making sure that in having it, just my monitor going out, having that preparation of just whatever can happen, have a backup computer. A lot of times, even if it's a virtual deposition or virtual mediation, I'll have them at my office so that we can control the environment that they're in and be ready for any of those backups. If they have to do it from home, obviously I know things are out of state. Make sure they're not getting any deliveries. Make sure they don't have a dog in the background. Although we do love Coco. Sorry, Ginger. I love Coco. So, again, making sure that they're in a room that's comfortable, that they have all of their information at hand. And I'm kind of going on, but I think that's pretty much basic for me getting ready for a deposition. And then, of course, from there, that's when I compile my deposition notebook.
Love that. I totally love that. I think for me, with our office, we have, okay, so let's take an expert deposition. So my function as a paralegal, as the information gatherer, will be to pull together everything that my attorney is going to need for that. Do we have an expert report? Has there been any discussions? Are there any attorney memorandums that were done based on a prior conference with the expert that has information that the attorney might want to have readily available? As far as preparation of an expert, that is typically done by the attorney or an associate, who will kind of have that pre-conference, that pre-depo conference with him. You know, it may be one meeting, it might need to be 2 meetings. So as far as the paralegal, I'll help coordinate with our scheduler to make sure that, you know, we've got a pre-deposition meeting set, whether that is by Zoom or whether that's by telephone. If the attorney's going to have to do it on the fly, if the you know, expert has the opportunity to do it, or if, let's say, we're a hybrid, we've got a treating physician that may give expert testimony and we've got his deposition up and coming. We want to make sure that we followed all of the rules for getting that pre-depo conference. Has the check went out? Because a lot of these doctors, they're not going to show up if they don't get paid. That was one of those things that you had asked Mr. Sessler before about keeping costs low for the client. So you have to work with that too. Do you need a 30-minute, you know, pre-depo conference, or can you get by with 15 minutes? Because I think most of the physicians these days charge in 15-minute increments. So but you know, you pull together the records for them. You know, what is there? What is a contradicting record that the attorney might need to talk to the expert or to the treating physician prior to the depo about? Is there something unusual in this case? Is there something that has now come up that you're wanting to know? Is it related? So those things, and because we're in, as a paralegal, we're in that file so much. We are probably in the file and going through the records and doing those things more than anyone else on a regular basis. You know, I mean, the attorney, of course, is going to know his file, but we're in it on a daily basis. We're talking to the client. We're, you know, following up on those kind of things. So we're going to probably know if there's something unusual that needs to be asked about. Something that now the client, you know, here we are 2 years later, and this is the first we've heard of a new ailment or a new symptom, you know, and maybe now the attorney, you know, we've got a deposition coming up and this new symptom, you know, what are we going to do with that? So we need to call that to our attorney's forefront so that he can ask that expert or that treating physician coming up. So you have to, this again is where you, as a paralegal, new or, you know, that's what they call it. You know, it doesn't matter how long you've been doing it. Whatever stage you are as a paralegal, your job is to know your case, be able to get with your attorney, give them all of that information that is going to paint the picture or is going to give them the quick reference for them to have that one word or 2 words that's going to remind them of a line of questioning that they wanted to give. And, you know, or you've got that symptom out there, big circled in red on that Post-it because you just found out about it, you know, 10 minutes before your attorney is going into the deposition, but you want to make sure that, you know, something happens with that. So you've got that down so he can either question around it or he can question directly, whatever his strategy is going to be for that. But as the paralegal, we are charged with gather the information, present it to our boss, let him decide how he's going to use it, what he's going to do with it. But you have to know your case and know it enough to be able to give him the tools that he's going to need to paint that picture or ask those questions, whatever it's going to be.
Well, I think you do yourself an injustice when you say you gather the information. You read, you absorb that information, and you know that information in detail. So it's you, not the attorney, who's reading the records for the first time, who says, we're missing pages. Where is this part of the file? Where, you know, we didn't get the whole set of medical records. That's invaluable, and it's so helpful to have a paralegal who knows the case just as well as I do, or if not better. Yes, it really is.
Well, thank you. Thank you for that.
So I can tell you're both detail oriented. And you
My
really
boss says all the time, he says, you know what I love about Georgia? She's detail oriented. You know what I don't love about Georgia? She's too detail oriented.
So
The only thing I was going to touch on again on the virtual, because I just, again, I can't say enough about the virtual files and how, and you can have everything in there. There's just no excuse not to have. The more the merrier, the more the better. Like, even if you set up a separate little folder that's just yours, so your attorney doesn't get distracted by it. You have everything at your fingertips in a digital file. But again, you want to make sure those digital files are documented correctly. Have you redacted any information you don't want in there? Have you made sure they're, that they're in the digital format that you want them in? Have you added the exhibits so that the court reporter can easily attach the exhibits to the transcript or whatever they're going to be doing or working with that? Like for an example, I'll try to, I don't know how familiar you guys are working with share documents, but I'll create a share folder, right, for all of my, like as a depository for all my exhibits, so that they're there and readily available to, whether it's the court reporter, opposing counsel can see them, my attorney's got them, and just making sure that you have all of that information ready to go, and just backing everything up. Do a test run of the deposition with your client digitally on Zoom, so that they know what to expect, so that they, again, have that backup of where they're going to be in front of the computer. And I'm trying to think of every single thing that the technology obviously is very important, which I'm mortified right now that my monitor went out. But and just making sure that you've got the backup, and that you're secure, that the information you're providing has that security that you've added to it when you've digitized it.
any tips when you're preparing a client for a deposition or any other witness? I like to use my iPhone and record. I'll pretend like I'm the opposing attorney and ask them questions and get them to answer and stuff. And then I can show them that recording, so they understand how they present and appear. But what I found is when the deposition happens, then they stiffen right back up,
Right back up.
really serious, and they forget to just be relaxed. And, they were so casual when we were doing it. Do you guys have any tips to work around that?
It's so hard. I do tell them to visualize. I say, before you go to bed, visualize that you're here, that everybody's here. And if you need to have some kind of, it's funny, like I had a girl, very, very, very stressed out. It was a dissolution marriage action. She was very nervous about being on a deposition. Have some aroma, have some candles around, some aromatherapy, whatever makes you soothing. If you can have something in the background, like just a soft music playing or something like that, it's like not distracting, but something that's for you. Have a favorite blanket over your lap, whatever it is to help you relax, because, and for me, it's always, these are attorneys, these are questions. Do not give yes or no answers. If they start talking to you, they start saying, oh, come on, how many times did you visit this, store? Or how many times did you, just trying to think of what it would be in a civil case, but, as attorneys, it's their job to say, well, was it more than once? Was it more than twice? Was it, I don't know is a good, if you honestly don't know, just because they ask it 4 more times, if you still don't know, that's an acceptable answer. Don't elaborate. Mark's a good attorney. He knows where they're going. Just wait for him to, wait till he can ask the question. Wait for him to make the objection. Same thing in hearings and trials, right? Just keeping them to relax, and just telling them, these are the questions that this is your life. These things, right? And I know sometimes people say this, but if you need a break, tell them you need a break. If you got to go to the bathroom, those are things that are actually acceptable to do. Just if you just need a minute. And of course, we say this a lot in family law because it gets very emotional. And I'm sure in the civil too, not to discount it, but it's just having those things that you prepare your client for the unexpected. Compare the, what could happen, but like you said, virtually making them as relaxed as possible. When they're sitting in a room with you, I find that they're definitely more secure. When it's virtual, it's almost game on. So I make sure they're very, very prepared.
Try to also just remind them. I mean, I might be a little bit more on the formal side because, the old adage, the KISS principle, keep it short and sweet.
Mhm.
You know, and then I remind them that this attorney is not their friend, but that it's not personal. This attorney is doing for his client. So for them not to take personal what's being asked of them. And also, you know, just answer what's asked and only what's asked. And that I reassure them also that the attorney is not going, their attorney is not going to let them be abused at the deposition. That he is there, he is their advocate, and he will not let them be abused. And then we also let them know that you'll process with them afterwards. So don't let anything, you know, don't let it stir them, just answer what's asked. They will make it through it, and then the attorney will process with them afterward.
Well, you reminded me, Susan, I had a client, he was incredibly nervous about his deposition, and it was a make or break deposition for him. At that time, we had an office dog, and that office dog ended up coming underneath the deposition table and putting his head on my client's lap, and that really made a huge difference. I mean, the client's voice was still wavering, he still had lots of emotion, but I think it gave him that comfort you're talking about. Yeah.
Right. And we have an office dog too, although I'm surprised he's not in here because as soon as I'm on a Zoom, he's barking at me. It's Mark's dog. But yeah, that's why I kind of said with my one client, I had her put a blanket on her. I said, just touch the blanket. It's like petting a dog, right? But she didn't have any animal. So just, you know, rub the blanket. It's soft. It's soothing. It's like, you know, it's not like a baby's blanket, but it, you know, it worked for her. You know, just finding what, and just, that's all I do is ask my clients, what relaxes you? What helps you? And when that one client said, well, you know, she likes aromatherapy, great, have some candles lit. You're in a deposition, it's virtual, you know, nobody's going to see your candles, nobody's going to smell here. I don't care what's, you know, whatever it is, you know, make sure you have your cup of tea, you know, make sure you're comfortable. And, you know, also I kind of tell them, if you can't look at the camera, you know, make sure you're answering the questions. But if you can't look at, if you can't look at the attorney, then look at the camera, look at your attorney, you know, don't focus on that attorney, you know.
I think that's really hard. And like even today, you're down on my screen, so I'm looking down at you. We've tried all sorts of different camera angles. We put happy faces on our camera. Just, you know, like this is the face you want to be looking at. But I think that's one of the difficulties with the Zoom format is just a lot of times maybe a document goes up or there's 4 or 5 different people on the screen. Is there a way that it would work in a deposition? It wouldn't work in a format like this, but is there a way that I can reorder faces on my screen? Can I like jump you, Susan, to the top and put Georgia down at the bottom, or vice versa?
That's a good question, and that I've never, and all of these Zooms that we've been doing for how many years now, I've never even thought of that. I mean, I know you can adjust your gallery view, but
can't you make it so it jumps only, like you can have it show only the person speaking?
you can do
there's
speaker
a gallery. This is the
gallery view, right? You can do
on.
speaker view, but in my opinion, I don't do that because I actually tell my clients not to do that because the only person they can see is the speaker, who's the person taking their depo, right?
Yeah, I like to see other people's reactions to stuff too. Yeah.
Right.
That's good though. The happy face on the camera. That would have to try that one.
Well, and I think
arrow. Look here.
I think I think the next step for me is going to be taking even the defense attorney's picture off their website or something and just putting it on the camera. So they have that face. It's not the happy face because it is the defense attorney. We want them to realize who they're talking to. So, and anyway, someone wrote on the chat, I've been instructed not to guess. I'm not sure exactly I'm sure that's a prep question you put out to clients, or a prep answer when you're preparing someone for a deposition. I've been instructed not to guess. It brings up to me another topic, and that is oftentimes plaintiffs' attorneys advise their clients to say, well, I can't remember, not at this time, I can't remember. It just sounds so stilted. So we've been working about other language, just like, gee, I can't remember right now. Right? Just a little bit more natural language. Do you have any tips like that to get out of legalese when they're being badgered by opposing counsel?
Not so much, other than because, and it's funny that you brought that up. I do, I tell my clients, I don't recall, I don't remember. Can you repeat the question? Those are very good. Those are acceptable answers. If you don't understand, don't try to, and exactly what that person says, don't try to guess what they're asking. Don't try to guess where they're going with this. Just, answer the best of your recollection. And if your answer is, this is to the best of my recollection, this, so I tell them, elaborate to that extent. Correct. Absolutely. But it's funny that you mentioned that, because we did do a very heated deposition, which is it was going to be one of my examples that I used if I had any, with a former husband on the other side, where we actually for trial counted, because when I say he didn't know the people that he worked with. He didn't know his new wife when the date, or that he didn't even know she quit her job. We added up. It was like in his transcript, it was a deposition transcript, I think just about 4 hours, was 280 I don't knows. So, and like 30 I don't remembers, and 50, right? So, you got to be careful. You got to tell your client, don't just do that, because we use that in trial, and the judge was like not happy about it. So you got to be careful when you do stuff like that. So, but yeah, to giving new answers, I don't have a tip, Georgia. Maybe you do.
Ooh, no, I really don't.
Well,
I
it's
think the
always
best
our
thing
burden.
is for them to just, keep it simple. And if they don't know, say, I don't know. That I don't know is an answer.
Right. I try to remind my clients, it's our burden. So don't fall into the trap of, okay, I'm going to get out of this deposition by always saying, I don't know, I don't remember.
Right.
Yeah.
Doesn't work.
Yeah.
So, but you have your clients who have brain injuries and they just really don't remember. So,
Or they remember things that didn't really happen, because they try to fill in the blanks, because they want to people please. They want to give that answer. They want this person questioning them. They want to answer them. They really, really want to. And so they try to, but they're putting in things that are not necessarily the facts.
Right. And do you have any strategies? Okay.
Hopefully the attorney knows how to switch it around and change the tone of the depo by going to another line of questioning and then back, and it'll just get lost in all of the back and forth. I don't know.
Oh, and that's true. Keeping up with your attorney at the deposition is sometimes really hard, because I try to make sure he's got all the, especially digitally, again, virtually, making sure that he's got all these documents ready to go, depending on where he's going. And then he'll jump to something else. It's like, man, that's not the order I was ready in. It's funny how they do that. I guess it's their depo, but
you talked earlier before about prepping the client and telling them what to wear.
Mm-hmm.
What about you, the paralegals? What if you're attending the deposition, if you're attending trial, if you're attending the mediation, how would you instruct young paralegals who are just getting started? What would you say? What is appropriate for you to wear?
Oh, please. And thank you for asking that question. I recently was at a deposition or a trial where I just absolutely could not believe what the paralegal was wearing. And she was young, God bless her. But, definitely very conservative. Don't come in there with your hair wet. Oddly enough, I've seen it. Make sure that you are definitely comfortable. If you're in trial, I know we're kind of getting off topic, but have everything that you need. I have a trial notebook. I have a briefcase. That's everything. And I take it to depositions, everything in there, stapler, hole punch. I have a sewing kit. I have, everything that I have, a credit card in case I have to get somebody something during trial. I have so many, and I can't even think of everything that's in there now, between Post-it notes, paper clips, all of the above. Change if you ever, I'm old school, change if you have to make do a meter, pay a meter. But make sure you have everything that you might need for that trial, but dress conservatively, dress up, don't come in there with a pair of slacks and a t-shirt and a frumpy sweater. I mean, get a nice suit. Make sure that you look presentable. I hate that that is important, but it really is. And we know that to be fact in our lives, that appearance matters. So I got told, I used to work when I was going to school to be a paralegal, I worked for a very prominent family law judge at the time. I was a trial clerk. And he said, your job is to make your attorney look good. And I'm not saying that you have to look good, but I mean, your presentation, as far as notebooks go, as far as trial prep goes, as far as pleadings goes, but as far as appearance goes, making sure that you look professional. It's all of those things matter in presentation.
Totally. That's what you represent. Each firm has their own brand, if you will, or their own I don't know what you would call it, but you represent your firm, you represent your attorney. The conservative dress, I think, is very important. You don't want to be the center of attention at a trial. At that moment, that is your client. Your client. You want the jury paying attention to the attorneys and the expert that's on the witness stand. You don't want them looking at you and thinking, oh, she was wearing, look at that bright orange shirt,
right.
or, something of that nature. You want conservative, you want to be there, you want professional, you want business. You have a job to do while you're there. And that goes for at a depo too. When you're at a deposition or even sitting in at a mediation, you are there to do a job. I learned that, not really learn that, but it really hit home for me because we had prepared so hard for this trial, and we got to the closing arguments and the final presentation. And my function was to help get the final jury instructions ready. So I didn't even get to see the actual closing argument that had been worked on so hard to tie it all in. And I think for a minute, I'm going to be honest, for a minute, I was disappointed because we as paralegals, we work very hard. We want to see all of that, and you get caught up in the excitement of the trial. But 2 seconds in, and then it was like, I have a job to do. I'm going to get it done. And had I not, we wouldn't have been prepared. It would have been a very difficult situation to get things final and through the next phase, which was the most important, getting the jury instructions done and to the jury and having them deliberate. So you have to remember, this is a job. It's, for some, it's, it's a passion. For me, it's a passion. I call it a career. A job, to me, a job's a job. This is what I do. This is what I love. And that's why I'm there. I'm there to help my attorney look good, present well, have the things he needs to best represent our client and bring it home and get that verdict. And that's what I do this for. And when we can get that, oh my God, what a great reward at the end to know what you've done for your client. It all comes together.
Yeah, the goal is definitely to make the best presentation you can for your client, for your firm, for the case.
No. I love just the thought to remind the paralegal and the associate and even myself, it's, this is the client's trial. We want the focus to be on them. We don't want the jury to be distracted by what one of us is wearing.
Right.
Yeah, no, that's a nice little tight summary. So, also, I've learned the hard way, make sure your client and your associate and your paralegal and your legal assistant, your IT people, try on their clothes before the trial. Insist on it. Insist on it. Because I have bought clothes for people who did not dress appropriately and said, here's a gift. This is what you're going to wear. And I said, I asked, how does it look? How does it fit? Oh, it'll be fine. Have you tried it on? No, but I will. But then showed up the morning of trial, 7 o'clock at the office. We had to be at trial at 9. Still hadn't tried on that shirt and tie. And put it on, and we wasn't even close to being able to button that collar. So had to make big apologies to our judge because in our jurisdiction, men have to have at the very least a tie on, if not the jacket as well.
Correct.
Client doesn't, but your employees do. So, I have another question. Well, I have another comment from one of our listeners today. What helped me for my deposition is prepping my client with printouts and food for and for myself a lot of coffee.
Excellent advice.
Yes. Do you ladies just meet with the client or the witness just once, or do you try to break it up when you're prepping for a deposition or even a mediation?
Oh, definitely at least 2 times. Because the second time I want to have everything that we discussed that they knew that they would need to be comfortable for that second meeting when we actually do sort of the run-throughs.
Okay.
Same here. And I might have a conversation with the client and just give generalities about whatever event's coming up, because then we're going to set at least 2 conferences with the attorneys. One might be just for some basic overview and just to get comfortable and have the client get comfortable on a Zoom, being as we are in the remote world now. And then there might be a more in-depth meeting after that to actually get down to some of the particulars of what they can expect at the event.
Do any of you ever show maybe another client who's been deposed that's been videoed, or another witness, of course, with that witness's or client's permission, to your client to just say, here's an excellent example of fielding a question or staying cool or just not getting sucked into a trap, or just the opposite. Here, this client broke that rule of keep it simple and short, right? They answered this question, they went on, and this is what happened. Do you do that at all or no?
No, the only thing I've really done is given clients a sample of orders, especially with their particular judge. I'm like, this is what you're in for. Look, because we have a judge in Orange County here that writes very specific orders and interesting ones. So they get an idea of what to expect, and I'll give them that. But no, I haven't never done the sample of them.
Okay. And it sounds like both of you are always doing this one-on-one with a client. You're not sending them a DVD or a video or a YouTube. This is how you testify. You make sure you take the time to do this one-on-one with each client. Is that correct?
For me, that's correct. Yes.
Georgia?
And it would be either myself or an associate, or even the primary attorney on the file would. We handle our clients very personal. It's a very personal touch when it's preparing your client for anything.
So no shortcut there by using a
No, sir.
Okay.
No shortcuts.
Okay. Someone asked, I lost the question. Maybe we answered it.
Sorry, I answered one. My bad.
Oh no, it was about a book. Do you have a book to recommend?
I just told her absolutely, and not necessarily about case and client, but there's a book called Question Behind the Question. It's an amazing book in life and in work that will help you deal with everybody, clients, work people, bosses, everything, yourself.
Okay. And do we know the author?
You know what? I thought I had it with me. No, but it's definitely on Amazon. It's like QBQ, and it's Question Behind the Question.
Okay. All right. Well, I'm impressed that you're multitasking even during this. So I think we have about 5 more minutes. Any other tips or tricks that you can share with us?
I did see one question that came from somebody. I'm not sure what it was. I think it was from Kim, and she says she hasn't been to trial yet, but she was going to wear a nice dress pants and blazer. And I'm glad you mentioned that. The old school used to be, and even in some courtrooms, women always had to wear dresses. I always suggest dress pants and blazer or a suit, because you never know what you're going to have to move, bend over, or do whatever you have to do to get a file to somebody, move quickly. And that dresses are just, no, not. I only wear pantsuits, because it's just, I've had so many times where I'm having to do a lot of bending over or reaching, and It's just, it works better.
Yes, or crawling under that table to plug
Right.
something in, because that's where the plug is.
Exactly. Yeah.
The only one that you can read.
The only one as your computer is going down. Absolutely.
Oh, yeah.
Well, I
And
know
comfortable shoes. Comfortable shoes for trial, because you'll be going up and down and in and out and back and, down that hallway. And, you have to, every time you have to go to the bathroom, or every time your client has to go to the bathroom, you need to go too. So
And
comfortable
just
shoes.
yeah, and quick, thank you, Ted. It's Question Behind the Question by John G. Miller.
Yeah, certainly for every young paralegal who's not gone to trial yet, somebody has to go with that client. Stick to them like glue, so they don't start talking in the bathroom about the case, so they don't encounter somebody from the other side or just even a stranger and start saying, "Oh, this is so terrible." I mean, clients do silly things. They'll say, "Oh, I'm bored to tears in there." And then that comes back out. Somehow the defense attorney learns of that and starts testifying and closing. This plaintiff was just bored to tears. You saw him, ladies and gentlemen. So yes, you definitely want to stick to that client like glue.
Well, sorry, one third thing. I know, Ginger, you were going to try to bring up what maybe towards the end, which we'll talk about what other conferences that are available for paralegals that are coming up. But just for me, for closing, I forgot to mention this: mediation, deposition, anytime that you're preparing these notebooks. And again, this goes with that theme. When you're done, when you've got your notebook done and you think you're ready to go, make sure you've gone back to your pleadings and you've gone back to whatever the relevant information is and do that checklist, that you've got everything that you need for that mediation, that deposition. I mean, just that's like the most important fundamental thing at the end is just going through to make yourself a checklist that you've got everything that you needed.
And would you mind sharing those checklists with our participants today? And also, I think just your notebook headings. I'm sure a lot of people would just like to see samples of those.
Yeah, I can get that to Ginger.
I know from an organizational standpoint, it's so easy to, when you see a well laid out notebook, it's great. But when you're trying to format one it's easy to get confused and like, oh, do I separate this from that? So I'm sure some people would like to just see some sample formats if you could share with them. So, and thank you for all your great tips and insight and wisdom. Thank you.
Thank
Great,
you, Mr.
great to be here.
Sessler.
I have had so much fun just listening to both of you, and Cash, thank you so much for moderating. We haven't done a paralegal webinar in a while, and we need to keep doing these, keep them rolling. But as Susan said, there are so many great things happening, and I want you guys all to know about what the National Trial Lawyers is going to be doing coming up in, it'll be Miami, right, Susan?
Correct, it'll be Miami.
Can you please just share a little information with everybody who's going to want to maybe be there or be involved in this great new adventure that they're going to be having?
No, I'm trying to look at, I don't have my dates in front of me, but I don't know, Ginger or Georgia, if you can look that up really quick. But so as they mentioned, I've been involved with the Mass Torts Made Perfect. They started a paralegal college, National Trial Lawyers, which is I don't know if any of you are familiar with that, which is plaintiff or civil plaintiff lawyers and criminal defense lawyers. It's an amazing organization. They do a National Trial Lawyer Summit each year in Miami. I know it's at the end of January. And us paralegals have beaten Keith Gibbons down, who's the owner of the Cochran firm and the National Trial Lawyers, and we've been able to get this paralegal track set up. This is the first one. It will be on whatever Georgia gives me the dates. It's the paralegals can attend the whole thing. And let me tell you, I've been going to National Trial Lawyers for probably about 6 years now. And it's very informative, even though before having a paralegal track, I learned so much. But now that we have this, we will have a paralegal happy hour where we're going to be giving away some really cool stuff. And that would be on Friday night, and you could attend all the events of National Trial Lawyers, which is amazing. Luncheons, events that they have. Cash, I think you go, right? And you've been there. It's just a great time. And then on Saturday morning, we will have a paralegal track session with some great speakers, including Georgia, some people from Levin Papantonio. I can't even there's so many great speakers that we're going to have, including my boss, Mark O'Mara, George's boss, Doug Bean. We're going to be kind of going through how paralegals and attorneys can speak to each other and how they can know their personalities to get things done, which is very interesting. So yeah, I'm hoping that you guys can get out there. They haven't opened up the agenda yet, but when you see that come through, definitely get your attorneys that you're on here, get your paralegals there. Paralegals, tell your attorneys you want to go. It's an amazing time, and it's I can't even explain how much you're going to learn.
And I will be there too.
Yes, Ginger will be there, and
I look forward to this every single year. It's such a well-run seminar, but there are just such great attorneys and staff, everyone that shows up to this.
right.
The
content.
Yeah,
the content's amazing, and you're going to meet like attorneys that you've only seen on TV, and I just have a great time.
Yeah, this will be my first time to go, and I am so looking forward to it. It's going to be so exciting. And I think those dates, Susan, is January 18th through the 21st.
Right, I think they're right.
Doesn't want to be in Florida in January, right? Where it's going to be
beautiful.
We're going to have a lot of fun.
Warmer. Yeah, us Floridians are cold, but it's warmer.
I'm looking forward to hot weather.
I've got Ted here with us. He is here to do the amazing coffee giveaway. Ted, we appreciate everything that you do over at HMR, but especially from me too here at Connectionology. I have loved working with you throughout the years, and everyone gets excited when they see you on here because they know you're about to announce somebody's name. So if you don't mind, who is the lucky winner today of the 4 bags of freshly roasted coffee?
Yeah, sure. It's Mackenzie Williams out of Tulsa, Oklahoma is our big winner today. So congratulations.
Awesome. Congratulations, Mackenzie. All right. Well, you are the lucky winner today. But don't worry if everyone watching has not won yet. There's going to be another chance because I'm going to be adding another webinar to our website today for one that we're going to do on Thursday, which is going to be great. So keep an eye out for 3 p.m. on Thursday. We're going to have another webinar. And then, of course, we're going to keep them rolling. We've got a lot more coming up next month as well, and also next week. So keep an eye on our website. And then Ted, you and I will both reach out to Mackenzie in just a little bit to make sure that she gets that special coffee. But thank you for being here day in, day out and doing this. It is so kind of you.
That's fun. I keep everybody caffeinated.
Which we need.
All right, Ted. Well, we will see you back again on Thursday. Looking forward to it. And then for everybody watching, just give me a few minutes and I will email you a copy of the contact information for all of our amazing speakers and partners that you've heard from today. And don't be afraid to reach out to them, please. I know that Georgia, Cash, and Susan would love to hear from you. So reach out to them if you have any more questions, or if you just want to say hello, if you just want to connect with somebody who's doing the same thing that you're doing. And, you know, even if you just got like, I don't know, you got a burning question, like, how do you do this? I think it's really important in this community for everybody to just don't be afraid to reach out and ask a question, you know, or just get connected with someone. And you never know who will end up becoming your friend. I have met so many people in this business now who are like family to me, including you guys. You know who you are. So thank you for all that you do. And again, thank you for everybody's time for being here to present with us today. Susan and Georgia and Cash, do you guys have any last minute comments before we head out?
No, just thank you. It's great to be involved. Great to be a part of this.
We need to do it again soon.
Yeah, love it very much. Thank you.
We will bring Doug, you guys, we promise. He had it was actually wonderful family things that came up. So he wasn't able to attend this webinar, but Cash was able to jump in. And Cash, we can't thank you enough for being here. You did a great job moderating. But we will have Doug back and we will have everyone together. We're gonna have a good time. Thank you guys so much again for being a part of all this.
So, and thank you, Connectionology, the entity that it is, for putting this on for all of us, because it really does make us all better at what we do. So thank you.
Thank you, Cash.
Thank you for sharing with us today, ladies. And thank you.
Thank you, sir, so much.
And Ginger.
Everybody. All right, until next time, we'll see you. Have a great afternoon. Bye, everyone.